Welcome back to the channel. Today's hearing is less, who did it, and more, how should courts do it? We're in People v. Cyrus Abati, and before a single piece of evidence is weighed, the room ignites over professional conduct and the mechanics of what evidence can be explored at a preliminary examination in a CSC context. The prosecutor sets a boundary. I'll argue law and procedure, not personal attacks, then alleges gender disrespect in filings and emails. The judge, firm, measured, and visibly concerned about tone, accuracy, and tradition. At the core lies a high-stakes legal duel. Does rape shield protection function at prelim the same as at trial, and does defense need a motion offer of proof before asking certain questions? Defense says no, citing MRE 404A to Swarnse, C, as a route to character of the complainant evidence without pre-hearing motion practice. The judge signals the opposite. The protections travel with the complainant, prelim or not. Stay with me. This is a masterclass in how procedure decides substance and how tone and advocacy can shift the entire courtroom center of gravity.
I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
Court does call the case of the people, state of Michigan versus Cyrus Abati.
Good afternoon, Your Honor. Mary Stanhouse, Assistant District Attorney.
And good,
People.
and good afternoon, Your Honor. With us, on behalf of Cyrus Abati, standing to me, right? Cyrus, please state.
Good afternoon, Your Honor. Cyrus Abati here.
Now that the case is formally called and appearances are on the record, watch how the judge frames control. This has come back to me. I have questions. Translation: we're not rubber stamping anyone's narrative. We're going to untangle both the filings and the professional dynamics. Prosecutor notes a filed response from defense and asks to proceed orally. That matters because it places live accountability on statements counsel makes today. Audience question: do you think oral argument helps de-escalate or can it inflame? In real courtrooms, it depends on precision and professionalism, two themes that will dominate the next several minutes as the judge warns that accusations like lying or sanctionable narrative require proof if you're going to say them in a public court.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, but I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. And quite frankly, no case.
The prosecutor takes a principled tack. Reputation and integrity are the currency of this profession. She emphasizes she's defended opposing counsel in past cases against unfair attacks, laying a foundation that her current objections aren't thin-skinned theatrics, but a professional boundary. This is savvy. It reframes the dispute as protecting courtroom norms rather than scoring points. She also distinguishes hard argument from personal insult, which is crucial for judges balancing zealous advocacy and decorum. For viewers, when lawyers insist, "This isn't about my feelings," what they mean is ad hominem shadows the record, clouds appellate review, and pressures witnesses. The judge will soon echo that. If you allege misconduct, bring receipts.
Is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I have an email, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin, and I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Douse to myself. It's in response to a request he made, a reply I sent him. Which again, we can certainly look at that, but this is the part I'm not concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated.
Here comes the flashpoint. The prosecutor reads an email, posture all you want, I'm seeing right through you, and alleges gender-based differential treatment. Whether you agree or not, this matters because judges must guard the perceived fairness of proceedings. The prosecutor asks for one surgical remedy, strike paragraph 5 of defense's reply from the public record. Not a sanction request, not a grandstanding demand, just a cleanup of the docket to protect the process. Engagement. Should courts scrub heated rhetoric from public records or leave it all to sunlight? Remember, judicial records aren't Twitter threads, they're official history. The judge's reaction in a moment will tell you how seriously decorum is being policed.
By defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me in the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get—
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
in the reply, specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit there and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback, mainly because.
When a judge says, "I expected better," that's a thunderclap. He's not ruling on sanctions. He's announcing a standard, persuasive briefs, not personal barbs. This sets the stage for the second act, substance. Defense insists it's professional, not personal, but the judge, drawing on decades of reading briefs, clearly perceives the tone as crossing lines. For the audience, judges don't just decide law, they manage the ecosystem of the courtroom: credibility, civility, reliability. If you lose the court's confidence on tone, your substantive arguments carry extra weight only if they're airtight, which brings us to the heart of today's legal fight.
You know me, I'll just be blunt. I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. I don't know. I just expected better. Go ahead, Mr. Dobbs.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Barr at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE.
Defense plants a flag. At prelim, MRE 45 Senate 2, C allows certain defense inquiries without a pre-motion offer of proof requirement borrowed from MCL 750.C 20J Town rape shield motion practice. In plain English, defense says the rule permits targeted questions now, and the statute's motion procedure is a trial stage gate, not a prelim constraint. This is a strategic wedge. If successful, it opens the door to lines of questioning that could shape probable cause. The risk? If the judge believes rape shield's purpose, preventing unfair intrusion, must apply equally at prelim, the court becomes the gatekeeper and can require formalities before any such questions. You're watching text versus purpose collide.
4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone,
The judge stakes a clear policy-driven view. Rape shield protections apply at prelim. Why? Because once sensitive sexual history is aired publicly, you can't unring the bell. He also references local practice, that colleagues have treated Rape Shield as applicable at this stage. That's powerful for a trial bench. Consistency supports public confidence and protects complainants from early potentially irrelevant invasions. Viewers, note the framing. The judge isn't banning relevant defense evidence forever. He's insisting on proper process so that any exception to Rape Shield is law-grounded and narrowly tailored, even at probable cause hearings.
We afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense, because it's one of those things that once the cow has left the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Das, I was a bit surprised by it, because your colleague, Mr. Shea, has argued the Rape Shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it, I put it in writing. I provided the court with the authority. What in fact I did was, I did not submit an advocacy piece. I did not, I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now, what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the Rape Shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Dawson, in this county where Rape Shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
The judge presses the logical endpoint. If defense argues the motion warrants offer mechanism doesn't apply yet, then nothing of that flavor gets in at prelim because the judge, as gatekeeper, will exclude it pending a proper showing. Otherwise, Rape Shield becomes a nullity. Defense counters with relevance under the court rules, but relevance alone won't override Rape Shield policy. Courts need specific statutory exceptions, adequate offers of proof, and a balancing that protects against unfair prejudice. Engagement. Do you think probable cause hearings should allow broader inquiry to test the state's case, or should privacy protections bind equally at every stage?
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
But I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of Rape Shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule says. So, if I can go back once more. The very core item that's at issue is whether defense counsel, before exam, needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Okay.
Spicy moment. Defense says it would ask for the legal basis if a judge demands a motion before inquiry. The judge retorts with the robe's reality, discretion to control proceedings and evidence flow. This isn't arrogance, it's a reminder that trial courts have broad authority to enforce order, protect witnesses, and structure proofs. Appellate courts later decide if that discretion was abused. Strategically, defense has preserved its position on the record, which matters for any future review. But today, the ruling will be about how the prelim will run, and that decision will govern what can even be asked.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that Fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is
Ruling landed. Rape shield protections apply at prelim to the same degree as at trial. Related evidence shall not be elicited unless and until the court has had a chance to evaluate the proffer under the appropriate framework. The judge directs the prosecutor to prepare the order. What this means for the next hearing, defense will likely need a targeted motion size offer of proof anchoring any proposed inquiry in a recognized exception with specific facts. For retention, this is a classic example of how procedural gates control narrative shape. The jury box is far away. These rulings determine what story will even be permitted to start forming.
the ruling of the court. Is there anything additional?
Briefly, Your Honor, regarding the date that this is scheduled for, it's November 10th. I will likely be in for trial unless it resolves starting on November 10th.
Summary. Today's session balanced decorum and doctrine. The prosecutor objected to personalized rhetoric and alleged gender-based disrespect, asking to strike a paragraph, signaling a commitment to professional norms. The judge, disappointed with tone, pivoted to substance and ruled that rape shield protections extend to preliminary examinations, functioning just as they do at trial. Practically, any defense inquiry touching protected areas will now require proper motion practice and offer of proof, with the court as gatekeeper to prevent premature and potentially irrelevant disclosures. The defense preserved its contrary legal position on MRE 404A and 2C for the record, but for this case, the courtroom's operating rules are now set. Your turn. Should rape shield protections apply identically at prelim to prevent unringing the bell, or should defense have wider latitude to test probable cause? CTA, if you found this hearing as revealing as we did, hit like, drop your take in the comments, and subscribe for more sharp, high-energy courtroom breakdowns, new episodes.
So I was going to see if the court had a